Service of process. Service is very important, and you must do it right. When you file a lawsuit, the defendant or respondent has the right to go to the court and tell the judge their side of the story. To do this, the defendant has to find out that you filed a lawsuit against them and why. So after you file a lawsuit, you must deliver a copy of the papers to the defendants so they can respond. This is called service of process. If the defendant doesn't respond to your lawsuit, it is called a default. If a defendant defaults, the judge will usually make the orders that you asked for in your lawsuit. But the judge will only make these orders if there is proof that the defendant was properly served with the lawsuit and had a chance to answer. The judge will look for a document called a proof of service. The proof of service tells the court when, where, and how the defendant was served. The person who gives the papers to the defendant is called the server. The server must be at least 18 years old and cannot be a party to the case. You can't serve the lawsuit yourself. You can have a friend, a co-worker, a neighbor, or a professional process server do it for you. In some cases, the sheriff can serve your papers for you. The professional process server, and sometimes the sheriff, will charge you a fee, but they know what they're doing and will fill out your proof of service correctly. The two most common types of service are personal service and service by mail. When you start your lawsuit, your petition or complaint must be personally served on the respondent's defendants. After everyone has been personally served, at the start of the case, service of other documents can usually be by mail. Personal service means that the process server gives the papers to the respondent defendant in person. Sometimes the process server will have to try a few times or wait for the defendant to get home or get to work. If the defendant doesn't take the papers, the server can leave them on the ground next to the defendant as long as the server sees the defendant and can identify him or her, or if the defendant admits she or he is the right person. For example, if the defendant is behind a closed door, the process server can't see him or her, so the papers can't be dropped off on the porch. But if the defendant opens the door, then the process server can leave the papers on the floor. That is valid service. Once the defendant is personally served with the lawsuit, future papers can usually be served by mail. For service by mail, the process server mails the paperwork to the defendant at his or her address. The process server has to complete the proof of service by mail. Remember, you can't mail it yourself. Personal service is complete when the server gives the papers to the defendant. Service by mail is complete 5 days after the server mails the papers. For more information on service, read the Code of Civil Procedure, sections 413 through 417. The proof of service tells the judge that the defendant was served, so it is very important that it is filled out correctly. If your proof of service is completed and accurate and the defendant ignores the case, you can get a default and an order in your favor. If there is a mistake on the proof of service, you may have to start over if you can't fix the problem. If you get a court order and the court later finds out that the proof of service was not correct or that you lied on the form, the defendant can get the order canceled and you will have to start all over again. There are forms you can use for the proof of service. Some types of cases like domestic violence and civil harassment cases have their own proof of service forms. If your case is a family law case, there is a proof of service of summons, FL-115, which is used for service of the petition and summons. Later, when other papers need to be served, you can use a proof of personal service, FL-330, or proof of service by mail, FL-335. For other cases that do not have their own proof of service forms, use POS-020 and POS-030.